Who stood right next to you? Twice. Yeah. Listen, some guys, they can't do it. Especially Charlie. Yeah. I see it too. You should see the hay man, like. What are you doing representing that guy? You know, that's what we do. I hope you die, stuff like that. Mm-hmm. Yeah. For the last year. That's the way it goes, baby. I'm in my business.
Forward, all right. Court is now in session. Please be seated.
Commonwealth versus Aaron Hernandez, indictment 2013-983. Counsel, would you identify yourself for the record, please?
Good afternoon, Your Honor. Michael Fee for the defendant, Aaron Hernandez.
Yes, sir.
Good afternoon. Andy Phelan on behalf of the New England Patriots.
Yes, sir.
Entered an appearance for the limited purpose of responding to the subpoena request.
Good afternoon, Your Honor. Patrick Palmer, Assistant District Attorney for the Commonwealth.
Yes, sir. First things first. This, in the ordinary course, would be what I call the first phase of a Dwyer-Lampron proceeding, in which normally I would look at the motion and affidavit of the requesting party, in this case the defendant, and determine whether or not there is at least a preliminary good faith showing that the items sought are evidentiary and relevant, and whether or not a notice should proceed. That is, a notice, not a summons, but a notice. And the protocol calls for a certain type of notice. It is more than just an alert to interested parties that there's going to be a hearing sometime in the future, but rather that notice is to contain certain types of information. It is my belief, I can be corrected, but it is my belief that no such notice is issued in this case because this court has not been called upon until this moment to issue such a notice. That notice may or may not be important, but it is part of the protocol, and I think it does have some significance here. So now I'm going to make inquiry of counsel for the New England Patriots as to its position with respect to whether your client is expecting or would benefit, in your view, by a formal notice issued from this court as a result of what, if anything, I do today with respect to this case. I'll hear you, sir.
Your Honor, in terms of whether the Patriots have standing to appear to let be heard on the Lampron factors that we have addressed in the opposition that we filed, if the court's determination will affect that, yes, we would like that notice. But we have received notice and we understood that we were to be heard today regarding the issuance of the subpoena, whether it should issue at all. And we believe that we have an interest in that.
Let me just say that I think with respect to both sides, all sides here, I understand that good lawyering requires you to be vigilant. And the defendant has issued, as we do in all motion practice, notice of a particular hearing at a particular time, or at least the notice that things have been filed, and you, being vigilant, appeared. But you understand, or I hope you do, what I'm saying. You're entitled to a specific notice, and I think that becomes perhaps relevant right now, because I have been reading in the last half hour or so this landslide of papers from both of you. And I think I've caught up to it. But I don't want to be acting precipitously with respect to anything. So I want to make sure that everybody is either ready to proceed on a second stage hearing at this point, or given the late filings here, and I don't blame anybody, I'm just stating the case. I just received this paperwork, I had to rush through it, I assume that the two of you may have had to do it, or the three of you may have had to do it. So I'd like to hear, I guess, from everybody on that particular point, whether the question being, do you want me to proceed to a second level Dwyer-Lampron hearing today, or should we take a breather and set that for another time when all of you, when all of us have had an ample opportunity to read and digest and to prepare a presentation upon these late filings? You're up, sir. I'll listen to you first.
All right. The Patriots are prepared to proceed today on the merits of the Lampron hearing. If the court needs to consider the arguments that we just received about 10 minutes ago in that last filing that was just filed with the court by the defendant, if the court needs briefing on whether we have standing to participate in the Lampron hearing, then we would ask for notice and that time to do so. But if the court is prepared to hear from the Patriots on the merits, we are prepared to proceed now.
All right, thank you. Sir.
Good afternoon, Your Honor. Your Honor, to the extent that the court is referring to the procedure very specifically laid out in Dwyer, in the appendix to the Dwyer case, I would submit that the bulk of the procedural requirements of notice in Dwyer have either already been complied with or are irrelevant. Dwyer, as you know, involved a request, as many of these Rule 17A2 hearings do, a request for sexual offender records, or records that are subject to a privilege, or arguably subject to a privilege. There is no argument, the Patriots have never claimed that any of the documents here are subject to a privilege. So
Nevertheless, you did choose Rule 17 in which to file this motion, did you not, sir?
We did, 17A2, Your Honor. And in response to that, we notified the Commonwealth, as is customary under this process. And indeed, I don't know if the Commonwealth did it, but the procedure says that the Commonwealth shall forward materials to the affected record holder. And that record holder, it's very important in Dwyer, and this is where the standing issue comes up. The record holder is to be informed that the hearing may be their only opportunity to address the court. And I think what we've heard today is that the recipient, or the potential recipient of this summons, which has not yet issued, is content with that, number one. And number two, they are also told, and it is a specific element of the appendix and the procedure, that they will be heard on relevance and whether or not a statutory privilege applies. That's all. And I think to the extent privilege comes into play here, it has never been into play. If there is a privilege, it is Mr. Hernandez's privilege over his medical records, which happen to be in the custody of his former employer. So we are prepared, Your Honor, to answer the court's question. We are prepared to go forward. We believe that the Lampron standards have been fulfilled in the filings that we made with this court. Judge Garsh expressly instructed us to determine whether or not there would be any opposition to the issuance of a summons. And we did that both with the Commonwealth, and we also did it as a courtesy to the ultimate recipient of the summons. What we heard back is that there is opposition from the ultimate recipient. That opposition, of course, could be aired in a motion to quash, as the Supreme Judicial Court precedent applies, not at the Lampron stage. The Lampron factors are designed for the Commonwealth, Mr. Bomberg, I'm pointing to the wrong chair, Mr. Bomberg. They are designed for Mr. Bomberg and the Commonwealth to determine whether or not a criminal defendant is abusing the rules and circumventing the discovery process that is spelled out in Criminal Rule 14. It is the Commonwealth's obligation to enforce those and inform the court. As the court says in Dwyer and as it says in Mitchell, it will welcome the input of the Commonwealth.
Most assuredly.
But there is no procedure other than in a privileged record setting for the ultimate recipient to actually address the Lampron factors. If the recipient wants to address relevance and have a limited opportunity to be heard on relevance, such as this is the wrong person, you have the wrong party, or if they want to be heard on statutory privilege, that's what Dwyer says, they may be heard on that. But the Commonwealth has no position and has not objected to the motion and affidavit that was submitted to the court. We know full well, Your Honor, that it's the court's sole decision as to whether or not the Lampron factors have been satisfied. We believe they have, and we are prepared to go forward today.
I understand your position, but what I haven't heard from you is this. I'll get to you, Mr. Baumberg. Part of the Dwyer protocol requires the Commonwealth, upon the approval of the court, to issue, to serve notice upon the parties, which shall include the motion that you file and the affidavit, or affidavits in this case. You file an affidavit before this court in June of this year. Your more recent affidavit was filed 20 minutes ago. The record holder has a right to full notice of the motion and the affidavit and the contents of that affidavit. It's not just simply, I read Dwyer to make that very clear, and I have to assure myself that the Dwyer protocol is either followed or waived, or there is a good excuse for me to carve out an exception. This is why I'm conducting this inquiry right now, sir. I'm troubled by these late filings, and I am very troubled, particularly in a murder case, about any shortcuts that I am being invited to take. I want to be very careful about that.
I understand that, Your Honor, and certainly we received the opposition from the Patriots yesterday afternoon at 4 o'clock over the wire. So, in reading that opposition, which is 13 pages, it seems clear that they have had notice, and I have heard counsel for the Patriots say that they have had notice as to our response and our affidavit. It is quite brief, Your Honor. It is 10 pages of memorandum, and it is 5 paragraphs, the 5th paragraph being redacted in the affidavit that was supplied to the Patriots because it contains material that would be most properly and addressed at sidebar with the court.
You're talking about your supplemental affidavit?
My supplemental affidavit, yes, Your Honor.
Mr. Baumberg.
I have to confess I haven't received Mr. Hernandez's supplemental affidavit, Your Honor. So I'm incapable of addressing that aspect of it because the Commonwealth hasn't been provided.
Well, now here's something, as has been stated to me, and I agree. This court could benefit by the input of the Commonwealth, but it should be informed input.
The Commonwealth was served by email earlier today, Your Honor, as in the same expeditious fashion that the parties to this particular hearing have been serving themselves. I'd be happy to provide Mr. Baumberg with a hard copy as a courtesy today.
You know, may I be heard briefly?
Yes, you may.
Mr. Fee's articulation of the standard in the Lampron in the 2 stages differs markedly from my understanding of it, including under the SJC's decision in Lamp, that there are 2 opportunities for the third-party recipient. Obviously, at this first opportunity, we are a party from interest with an interest in the records that are being sought. With regard to whether there is a privilege or, as we mentioned in our brief in one of the footnotes, with regard to the scouting records, we have a trade secret proprietary interest in those records that would be addressed at the second hearing if a subpoena were to issue. But we are here today to address whether the requirements of Lampron have been met because we are a party of interest. We have received notice and we've been informed, and the case law apparently says, even the case law that Mr. Fee cites, indicates that we will be heard. I am prepared also, Judge. I don't want to put the judge in the court in a position of not having ample time to review this. I am prepared also to put this off if the court would like us to do so.
What I want to hear from you, sir, is whether or not you, on behalf of your client, waive the notice requirement as articulated in Commonwealth versus Dwyer.
No.
You do not?
Do not.
All right. Then I'm going to proceed as, I think that answers it for me. Without the waiver, of party of interest, I don't think I can appropriately proceed to Phase 2 Dwyer Lampron. I'm going to stick with Phase 1. Accordingly, I shall hear from the defendant, the moving party here, as to why I should issue a notice under the Lampron protocol pursuant to your motion, sir. I'll hear you.
Thank you, Your Honor. Your Honor, the defendant was charged with multiple crimes, including first-degree murder, in June, at the end of June of 2013. On July 31, 2013, counsel for the defendant sent a written letter with a written release to the New England Patriots asking for a copy of the defendant's personnel records as well as medical records accumulated by his employer during the course of his employment. That would be a full file consistent with the Massachusetts Personnel Records Law and Mr. Hernandez's right to access the materials that are held by his employer. That was July 31st, Your Honor, 2013, nearly 1 year ago. We heard nothing from the Patriots, no response whatsoever. A telephone call was placed to the Patriots on August 20th, 2013, in an attempt to determine whether or not they had received the release and they had received the request. We were told that there was no information available. We could not respond. It was very difficult to try to find a name. The person on the phone was named Drew Kruger, who said that we would have...
Yes, I'm sorry, but what's the source of this phone information?
This is Exhibits 1 and 2 in the motion, Your Honor?
Yes, yes. I followed that. But who gave you the information that you're articulating right now? Who spoke for the Patriots in that message?
An individual named Drew Kruger.
Fair enough. Thank you.
Yes, sir. Later in that, Drew Kruger said that this was a matter that would have to be addressed with legal counsel. He was asked, as is detailed in the letter that is attached to our motion, he was asked who legal counsel is. He said he didn't know. Another call that same day was placed to the New England Patriots, and my co-counsel's paralegal asked if he could speak to legal counsel for the Patriots. Was told that legal counsel was not available and that policy prevented the disclosure of legal counsel's name. That same person then did a search on LinkedIn, found the name of a person identified as counsel for the Patriots named Corbury, called that person at the Patriots, left a voicemail message on August 20th asking for action on the July 31st written request. That's all that's necessary, was a release authorized by Mr. Hernandez, signed by Mr. Hernandez, asking for his file. There was absolutely no response.
And your client signed that release and you sent it along to the New England Patriots?
We most certainly did, Your Honor, and a copy of it is attached as in Exhibits 1 and 2 to our motion for the issuance of a subpoena pursuant to the rule.
And this person actually said that there was a policy that precluded them from divulging the name of counsel?
That's what's summarized, Your Honor, in the letter.
I read that. I just wanted to hear it from you.
Yes, sir. That's my understanding. I wasn't a party to the telephone call, but it was, as I mentioned, the paralegal manager for my co-counsel's law firm who had that conversation.
All right.
We subsequently, on September 12th, sent a comprehensive letter detailing these efforts to obtain this information to the Patriots, asking them again to please respond. We received nothing, Your Honor, not a bit, not a phone call. We received no response. And so thus we are now confronted with the situation of being in a pretrial posture where Mr. Hernandez has made an informal and proper request for access to this information. It has been ignored. So unfortunately, we must go to the pretrial subpoena process under the rule and under land.
Do you think that you'd be able to get those records directly as an employee seeking from a former employee seeking from his former employer?
Absolutely, Your Honor. That was our assumption. We never expected in a million years that the Patriots would refuse to even acknowledge that a request had been received.
I think I follow you so far, sir, but I can't quite let the ball drop there, if I may use that metaphor. Look, you've read the New England Patriots paperwork on this matter.
I have.
They refer to a variety of efforts to resolve this matter, or at least so it seems. And now and I read your affidavit, I've read those letters, you seem to be at aces and eights here. What's the story?
We've come down to, and we must rely on the Patriots' representation on this, Your Honor. Excuse me. We've come down to what they represent to us to be two categories of documents that they are withholding.
We'll give you 317 pages of documents.
Right.
That's what they said.
That's correct. That's not consistent with our request for the personnel file of this former employee because they are holding back two categories of documents. One they describe as a combine report, which is a psychological assessment. And we have furnished the court with background information about this psychological assessment.
Yeah.
And we believe that a psychological assessment is eminently relevant and eminently useful and eminently attainable by a criminal defendant in a homicide case as a criminal defendant goes forward and faces these charges and looks at a possible trial. So this psychological assessment, and there's no question that it's a psychological assessment, there's no question that it has value. Indeed, the head coach of the New England Patriots is a spokesman for the company that articulated or that presented this report.
Everybody in this room knows that your client's state of mind is an issue in this case.
Absolutely, Your Honor. It's a mens rea crime, and state of mind is critical. And it's the basis for our request. This is not a fishing expedition. We're not on a lark. We're looking for solid evidence about our client that we are entitled to receive given the nature of the charges that have been brought against him. So we are looking for that report. Mr. Phelan and the Patriots have said you cannot have that report. He offered to, we have been talking to try to resolve this, absolutely. We've made proposals and they've made proposals, but his proposal was we can't have it. I could come to his office and look at it, but we could not have it.
Well, he goes further than that, doesn't he? And it is germane to these particular proceedings. You have explained, you've been very careful in explaining how you've not been able to get this information otherwise. In fact, you've proceeded upon that explanation, and I've taken good notice of that, I think, in your paperwork. But in this instance, this particular combine report, the New England Patriots, in opposition to your motion, say, look, they could get this from the vendor himself. Yeah. What do you say about that?
I say that that's a dodge and a feint. And I say that this is a document that falls well within the definition of a personnel record under Chapter 149, Section 52C of the Massachusetts General Laws. And I would say that this assessment of this employee, this evaluation of the employee, is a personnel record that is readily obtainable by this individual. Why, Your Honor? When we think about trying to, think of the Lampron, one of the Lampron factors is to try to avoid delay in heading towards trial. Why is it a remedy for Mr. Hernandez to go to a strange vendor with an out-of-state service process of a subpoena and obtain the record there, as opposed to going to Foxborough, Massachusetts, and having them open up his personnel file and give it to us? That's not an answer. It is not readily attainable with the exercise of due diligence. I would say, Your Honor, quite the contrary. Due diligence is going to the nearest, least expensive, most appropriate source for that document. The fact that it was generated by some vendor who has an office in an out-of-state location, that's irrelevant to the fact that it's in Mr. Hernandez's personnel file. And it's a psychological assessment, and we are dealing, as you said, Your Honor, with a mens rea issue in state of mind in homicide cases.
All right.
The second category, if I may, Your Honor?
Yes.
The second category is scouting reports.
Yes.
And we specifically asked for scouting reports. We specifically asked for these assessments. And we believe, and indeed, the description on page 6 of the Patriots' opposition to our motion for the issuance of a summons describes the content of the scouting reports. We were, Your Honor, as you talk about compromise, our counterproposal was, please give us a copy of that psychological assessment from TAP, and in exchange, make the scouting reports available at your office. We will not pursue the scouting reports if it turns out that the scouting reports don't have any relevant information in them. We suspect they do, Your Honor, and I have detailed this.
What happened to that request?
It was denied last night.
They say I'm just trying to maintain this, make sure we stay focused here. You're right, if I understand you correctly, and I'm going to invite counsel to respond to this, but the scouting records also and I'm quoting here, scouting records also contain brief blurbs from scouts, parens, non-medical personnel with football expertise, end parens, on personality and character traits, assessments of ability to compete at the professional level in comparison with other draft prospects, end quote. Is that what you're talking about, sir?
Yes, sir. And we have detailed in our reply memorandum the reasons why. Number one, again, we think those would fall into the type of behavioral, psychological records that would be relevant in a state of mind crime. Number two, there have been, as I detail in the memo for the court, there have been referenced in the media, referenced in court, and referenced extensively in discovery materials alleged prior incidents involving Mr. Hernandez prior to the time he became an employee of the Patriots. We believe those incidents to be unfounded, and we would expect that a scouting report with these types of background investigations and these blurbs and these investigations of the very attributes and characteristics that Your Honor just read would have addressed those matters and would have found them to be unfounded, or else how could this individual become an employee of the New England Patriots? So we believe there's also exculpatory information in there in the event that those episodes come up at trial for prior bad acts or under the rubric there. So we believe that the scouting reports, if they are thorough, would probably address that as well as the behavioral, cognitive, and sort of psychosocial issues that would be assessed. A third-party assessment of that nature, Your Honor, would be critically important to an assessment of the kind that all defense counsel do as they prepare for trial in such a case.
Thank you, sir.
Thank you, Your Honor. May I just add one bit, Your Honor, which is I would, if the court would permit it, I would like to address at sidebar just one other aspect of this case in an ex parte fashion, because the public disclosure of such would intrude upon attorney work product and preparation for trial. But I'd be happy to discuss that with the court ex parte.
I'll keep that in mind. I'm not going to respond to that just at this moment, sir.
Very well.
But thank you. Commonwealth.
Your Honor, on the issue of the scouting reports containing or possibly containing evidence of prior bad acts, I just don't think that's the case. That argument, whether they do or they don't, that argument is not an argument for the production of those particular records. Mr. Hernandez is alleged to have shot Alexander Bradley in the eye and participated in the shooting of Mr. Bradley in the eye just some number of months prior to the homicide of Mr. Lloyd. That was well after he was employed by the New England Patriots, after the draft, after the scouting, so that's clearly not in those reports. Mr. Hernandez is alleged to have killed 2 individuals in the city of Boston after the scouting, after the draft, and while he was employed by the New England Patriots. So that's clearly not in the reports. There's allegations that Mr. Hernandez has possessed guns over an extended period of time, but not information that was publicly known. Some of that predates his being drafted, but that was not publicly known, and in large part the allegations that have been laid out of Mr. Hernandez coming into contact with guns on a regular basis is all after the scouting, after the combine, after the draft. And so that's clearly not going to be in those reports. To suggest that a scouting report is a definitive study of the defendant's prior criminality is clearly not something that's supportable on its face, Your Honor, because there would be no way of knowing the things that Mr. Hernandez was concealing from the public and from scouts prior to his being drafted, and obviously that those things that he concealed after the fact would not be contained in those reports. So that is not a basis.
What do you say, Mr. Baumberg, about the description offered by the New England Patriots that these reports do contain brief blurbs of comment, apparently, upon personality and character traits.
That's as it existed at the time he was drafted, Your Honor,
Yes, I think
which is
you're
some
right.
number of years before. The defendant's suggestion is that whether or not he clearly hasn't stated, Your Honor, whether or not he is placing his mental state at issue as sort of a factual predicate, right? He hasn't suggested that. He's stated only that this is a crime for which the Commonwealth is required to prove a particular mens rea. He has not stated that he's placed that into issue. So, but that is in issue as of June of 2013.
Is that the point at which I have to make a decision, Mr. Bomber?
Well, on the issue of relevance, I think that the question of what his character and personality traits were, so not his mental state, his character and his personality traits were, some number of years before, I think that the court has to, and I'm not suggesting that it is self-evident or solves, that the question answers itself here, Your Honor, but those two things don't equal each other. And so on the issue of relevance, and when you're weighing relevance against the record sought, and whose record is it, and what steps have been taken to obtain that record from the actual person as identified by the New England Patriots in some of these reports that aren't their own internal records, I think that is all part of the calculation.
Thank you.
Your Honor, if I may just respond quickly to the Commonwealth's recitation, and with all due respect to Mr. Bomberg's recitation, I would suggest that he review the discovery that his office has provided to us, and also review some of the facts in this case. Mr. McCauley stood in this courtroom a year ago at a bail review hearing and held up a photograph from 2008 from TMZ, or referenced this photograph taken in the dormitory or the off-campus housing at the University of Florida, alleging that it potentially represented the murder weapon. Completely unfounded, but nevertheless, this photograph, which has now been tracked by the District Attorney's Office by satellite and pinpointed to this residence, all in discovery, very much occurred before Mr. Hernandez was scouted or employed by the Patriots. Second, as Mr. Bomberg knows, we've received discovery, and they have interviewed law enforcement authorities in Florida about incidents in Gainesville, Florida, involving an alleged shooting in Gainesville, Florida, that at one time was supposed to have implicated Mr. Hernandez. It did not when it was
investigated it, but is any of that material relevant to this case?
Well, we don't know, Your Honor. It was relevant enough to be included in the discovery, and we don't know what they're going to put together. It was relevant enough, a photograph, an unauthorized, an unauthenticated, photograph from a gossip channel was enough to have an assistant district attorney stand in a courtroom in a bail review hearing and reference it. So I believe it is relevant, Your Honor. I really can't believe that we're parsing these types of materials in a homicide case. It's incredible to start drawing these date lines when we know for a fact in the discovery we've received these episodes in Gainesville, which also included a fight at allegedly at a bar involving Mr. Hernandez. We don't know if they're going to put in evidence that he has a propensity for violence or has a familiarity and a regular access to guns. We don't know any of that, but that all predated his joining the New England Patriots, and we do have a well-founded basis, Your Honor, to include that among our reasons. I wouldn't include it as our first reason. Our first reason is precisely what Your Honor has focused on, those assessments of characters, trait, and more of the psychosocial factors.
That's an argument against something that I did not argue. One said most of these weapons he's alleged to have possessed happened after the fact. And specifically, it did not say he didn't exempt or possess weapons prior to that. But as what I did say, Your Honor, is that much of this stuff, the fact that the suggestion is that it doesn't appear in a scouting report, it didn't happen, and therefore there's some relevance to it. That is not a reasonable argument. Not only have we produced the photograph, we've shown what phone it was taken from, where it was taken. We can show that it is authentic because it has been analyzed. And so the idea that I made an argument that I didn't make, that's not what I said. Second, and I neglected to add this, the idea that the defendant doesn't know who Mr. Phelan is, I think is also not supportable by the evidence, because Mr. Phelan has been identified on a number of occasions to Mr. Hernandez in the course of the investigation, in the materials that are in the discovery, because Mr. Phelan himself has been identified in reports and in other materials. So the suggestion that they didn't know who Mr. Phelan is, I'm also going to suggest to the court it's not factually based.
All right. Sir, I'll hear from you. I know that I'll hear from you.
Sure. Your Honor, what I'd like to get back to here is a discussion of what the SJC, the Supreme Judicial Court in this jurisdiction, says is required for a Rule 17 summons to issue. And I haven't heard much about that today, and haven't heard much about that from the defendant. I would like to do it in three...
We're not there yet, sir. The question before this court is whether I issue a notice.
Okay.
But I'll hear you.
With regard to, and the court put its finger on one of the issues, with regard to the medical records and the personnel file, we have offered to defense counsel, to the defendant, to produce the 317 pages. All we are awaiting is a current, we must have under the law, a current authorization, and we have not yet received that. I believe Mr. Fee is aware of that. He told me he would get it to me. I have the documents here. I can give them to him here. So that takes care of the personnel files and the medical records, and we're back to two documents only. The scouting records from 2009 and 2010, and the 2010 Combine report. Let's start with the Combine report, 2010.
All right.
First. Let me address first relevance with regard to mens rea and state of mind. The mens rea that is at issue is whether on that night in June 2013, Mr. Hernandez intended to do the acts that the Commonwealth has charged him with that resulted in the death of Mr. Lloyd. That's the mens rea, and that's the state of mind that is relevant. Under Rule 14, if the defendant is going to put his greater state of mind at issue, meaning his capacity, his ability to understand, a mental incompetence, some kind of diminished mental capacity, he must put that at issue. So the records that he seeks...
Just in the fact that there's a first-degree murder indictment pending against this defendant, doesn't that also place before this court the question, or ultimately before this court, the question of whether or not second-degree murder would be a more appropriate charge, or, with certain facts, a lesser species of homicide?
If the defendant puts his mental capacity at issue, the answer is yes. With regard to more generally, and whether he is simply searching as a matter of fishing expedition, general discovery, which Rule 17 does not allow summonses to be used for, the answer is no. And under Lamb I used as an illustration in the brief that I submitted because Lamb goes into detail. There was an individual there, the defendant, charged with sexual molestation of a child.
Yes.
And he served a summons or notice of the summons.
The parents and all that.
Yes. And with regard to the school, he asked for several years of records both at the elementary school and at the middle school. And the SJC reversed the trial court and said, no, you should not have issued that subpoena. And we will tell you what is relevant with regard to the crime charge, and that was the dates on which...
That's a bit of an overstatement, is it not? Didn't the Supreme Judicial Court allow a portion of the summons to survive and vacate a further portion?
As I understood what the court did, the SJC reversed, remanded to the trial court with instructions because I believe it was Lampron that was decided in the interim, and so that guidance wasn't there. So I think that that's what happened, but the court gave guidance on what would be relevant. And what it said was, he is charged with the indecent assault on a child on September 8th and September 10th, 1999. We will allow that part of the summons that he sought as to September 1999, but not more broadly than that. That is an obvious assessment of the affidavit facts that were presented and the crime that was charged. Just because Mr. Hernandez is charged with first-degree murder doesn't mean that everything becomes relevant that might have some bearing on his mind. His mens rea that matters is what his mens rea was on the night in June 2013 when Mr. Lloyd was killed. And the 2010 Combine report was 3 years earlier. It has no bearing on his mens rea or his state of mind on the night of the alleged murder. In addition, and this goes to the other point that the court was making, we have offered to defense counsel the opportunity to come in and look at that document. In terms of the relevance and his ability, in terms of relevance, part of the relevance, the first prong in Lampron is it must be evidentiary and relevant. And the evidentiary provision is that it must be likely to be admissible. In the hands of the Patriots, it is hearsay. In the hands of the entity that obtained it. I'm sorry?
What are we talking about? When you say it?
The 1.5 page high-level summary that we have.
The Combine report.
Yeah, the Combine report.
All right.
It is hearsay. And we have told and we have directed defense counsel to the source of that information as to whom it would not be hearsay and who have the underlying documents, whatever test was performed. The Patriots have none of that. They just have a 1.5 page summary of hearsay. So under Lampron, one of the criteria is that can it be obtained from another source? Yes, it can, but it also relates, so that's a prong that isn't met, but it also relates to the fact that it must be admissible. And in our hands, it's not disputed that it would be admissible.
Likely to be admissible.
Yes, I'm sorry, likely to be admissible.
All right.
Now, with regard to the scouting reports, again, if we go to the relevance, the mens rea again, we're talking about what is relevant being June 2013, the night of the murder. These scouting reports contain those blurbs that the court mentioned as to 2009 and 2010, 3 and 4 years before the murder of Odin Lloyd. So they have no temporal relevance. And as we point out in our brief again, in terms of relevance, they must be relevant to an issue in dispute in the case. And the defendant has not asserted under Criminal Rule 14 that he is putting his state of mind and his ability, his knowledge at issue. When you step back and then look at the remainder of the subpoena and these 2 documents that are sought, it is a fishing expedition. And I use that term, I don't like to use a colloquialism, but that's the term that this SJC has used, because it's trying to point out that a Rule 17 subpoena has a very specific purpose, and it is not to be used broadly to search out discovery and to search out for information that might possibly prove useful. It must be for an issue that is actually relevant. And so Mr. Hernandez has not met that standard because the affidavits that were submitted on his behalf are completely conclusory, involved in the assertions that they make.
Not anymore.
Well, the additional information that I received 10 minutes before this hearing started, that I had a chance to review, confirm with regard to the 2010 Combine report. That's what they particularly address. They confirm that he should go to the third-party vendor, whom he knows who they are, and get it from them. Because all of the information that he has in his affidavit that seeks to buttress this 2010 Combine report regards whatever specifics went into that report itself. All the Patriots have is a 1.5-page summary that has a copyright on it that says we can't release it. It belongs to this third-party vendor. But the third-party vendor has first-hand knowledge of the test, the analysis, and how they came to the result that they came to. So for all of these reasons, the court should deny and it does not need to issue the notice because they have not met the standards under Lampron to have a subpoena issue.
Thank you, sir. It's all right, sir.
May I, Your Honor?
Why don't you let me speak for a moment? I'll be right back to you. I don't mean to be rude in any respect, but I want to get to a point that I think I have to make here. I have reviewed the defendant's motion and his 2 affidavits along with the supplemental material. And considering that, and even considering the first affidavit alone, a significant portion of which deals with the efforts, the unsuccessful efforts, to secure information from his former employer, which, to the view of this court, could have been resolved many months ago, and it's at least odd that it hadn't been resolved. But nevertheless, I understand that those conversations, if any there were, or to the extent that there were, have placed the defendant in the situation of not knowing for certain what the records contain, other than his efforts, and I think they are good faith efforts, to describe them to this court And this court is satisfied that the defendant has, with sufficient specificity as he has been able to do with limited access to information from the New England Patriots, he has shown with reasonable specificity the relevance of the requested documents as articulated in his motion. His motion for a Rule 17a summons. I am not issuing that summons at this point. I am, however, instructing the clerk of this court to issue a notice for a hearing, and I'm going to seek the cooperation of counsel right now in terms of setting a date for that hearing. And that notice will be compliant with Commonwealth versus Dwyer. It shall be issued to the District Attorney's Office, who will facilitate its being served upon all interested parties, including with the motion and the affidavit and the supplemental affidavit to the New England Patriots and any other interested party that the Commonwealth determines is an appropriate receiver of such notice. And at that hearing, this court will hear from counsel, it will give a full hearing to all parties, and it will determine whether or not a subpoena under Rule 17 should issue and the contours of that particular subpoena. It will also entertain it will also make a determination as to whether or not the subject matter is privileged or not privileged, or at least presumptively privileged or not presumptively privileged. And the court will entertain at least the possibility of issuing protective orders to protect the interests of all parties, the defendant, the Commonwealth, as well as the New England Patriots and any other interested party who adheres from appropriately at that hearing. I now call upon the parties to agree on a date for that further hearing.
Do you have an approximate period, Ron?
Well, I leave that to you, but I guess this issue is something that I've got to take personal care of, and but let's hear what you have to say first. I know you have other matters pressing, and I don't want to intrude upon those, but I know you have, certainly the defendant has an interest in a prompt disposition of his motion.
Your Honor, from our perspective, I'd like to do it before the one-year anniversary of our informal request, which is the 31st of July, and we'd be prepared to do something next week. We'd be prepared to do something the week after, the week of the 21st or the week of the 14th, if the court's calendar and Mr. Phelan and Mr. Bomberg have availability during those weeks.
Okay.
I take it then that Mr. Hernandez is not pressing the issue of whether or not he should serve, the Commonwealth would serve the Dwyer notice to the actual producer of this record that is not the New England Patriots.
I'm sorry.
The New England Patriots have raised this issue, Your Honor, that it is not their record, that it is merely a summary that they received from this outside agency, a vendor.
No. The notice, as I understand it, Mr. Bomberg, is specifically to be addressed to the named record holder named in the motion. The named record holder is the New England Patriots organization.
That's correct, Your Honor. We're just seeking these records from the Patriots. We're not seeking them for anyone else.
Well, no, but I want Mr. Bomberg rises and speaks a good point, and I want this particular notice to be correct and properly addressed. The New England Patriots has told me they're not waiving their rights to that notice, so I want it to be done correctly.
The week of the 21st is fine for the New England Patriots.
Mr. Clerk, you want to weigh in on that week? How do we stand?
Any day. I'm sorry? Any day at 2 o'clock would be.
Any day at 2 o'clock, gentlemen, the week of July 21. This court will make itself available to you.
Tuesday the 22nd, Your Honor?
22, Mr. Bomberg says yes.
Mr. Phelan says yes.
July 22 at 2 o'clock. Any questions? Any questions?
One more, Your Honor, just you laid out the issues that the court will address at the hearing. Will the court also address the standing of the third-party record holder, the extent of standing in terms of, I know Mr. Phelan has already addressed the Lampron standards, which we would object to for the record.
I will, yes, sir.
Thank
Yes,
you.
sir. I'm aware of that, and with your papers, I know that Mr. Phelan has been put on notice.
Yes.
With respect to that
Thank you, Your Honor.
issue. Anything else? Thank you all.
Court, all rise.